versus Curtis German, file 25-6963FC. Counsel, you want to state your appearances, please?
Melissa Goodrich, White County Prosecutor.
Thank you, Honorable Worthy of behalf of Mr. Jarman, who's your seated to my right.
All right, and we're here for sentencing on criminal sexual conduct, second degree, person over 17, victim under 13, 15-year maximum, and 2 counts of CSE third, 15-year maximum. The guidelines advisory are scored at 50 to 100 on the second degree and 78 to 130 on both third degrees. Mr. Gurmurthy, have you had a chance to review the report and recommendations with your client?
I did receive the report, Judge, in the sentencing information report. I reviewed that with Mr. Jarman, and I also reviewed the sentencing information report. I don't have any challenges to the body of the report and no challenges to the scoring guidelines as well.
All right, Ms. Goodrich, do the people have any additions, corrections, or scoring challenges?
No, Your Honor.
Mr. Gurmurthy, anything you want to say on behalf of your client?
I do, Judge. Thank you. Judge, Mr. Jarman is 35 years of age. This is a tough case. This is a tough case all the way around. Victim in this case was 11 at the time I think the disclosures were made. She's probably 12 now. Mr. Jarman had some legal challenges in this matter while we were at least litigating this matter. But in reviewing the evidence, the plea offers, the sentencing guidelines, the Alpina case, and how we resolved it, I think it made sense to resolve it the way we did. Mr. Jarman certainly has been remorseful and apologetic for his conduct. Mr. Jarman comes with his own set of challenges. He has some mental impairments that affect his ability to process and process things. Again, it's not a defense to what happened in this matter, but it certainly goes to why Mr. Jarman is in the position that he is. Mr. Jarman takes things very simple and understands things in a very, very simplistic manner and doesn't process the seriousness of the conduct and his actions the way they are. I certainly am hopeful that with the 8-year cap that we have, Mr. Jarman gets the necessary help that he needs to get while he's incarcerated in prison, goes through the proper courses and educations that are available to him while he's incarcerated. He has done so while he was in jail here. CMH was involved. I think they've reviewed his medication. So those things, at least while Mr. Jarman was here locally, have started. Mr. Jarman has support of his family as well. And it is important to also know that Mr. Jarman did waive the prelim in this matter. We were set for an exam. We again evaluated our case at the time of the exam.
Opening music and procedural kickoff. The court clerk and prosecutor's state appearances. Judge announces sentencing on 3 counts of criminal sexual conduct, second and third degree. Lays out the statutory maximums and advisory guideline ranges, and confirms defense review of the pre-sentence report. Part 2.
And he didn't put the victim through any testimony and go through the prelim. So I think that's also to his benefit to understand the ramifications of how this process works. And certainly it resolves the Alpina case that's pending as well, because now the victim doesn't have to testify in 2 counties and in the same matter with similar allegations. I would ask you to follow the sentence agreement in this matter. I think we scored Mr. Jarman. The family was on board. This makes sense overall for the family, for Mr. Jarman, in resolution of this case. And again, as I said, Judge, Mr. Jarman is apologetic, difficult case, but I think it makes sense to resolve it the way we did. So I'd ask you to follow the sentence agreement and then sentence Mr. Jarman accordingly. I know we talked before we went on the record about the lifetime monitoring issue. I think the court needs to address that in the report. Mr. Jarman indicates that he's going to be moving to Florida once he's released from prison, and he believes that he wouldn't have to be on the lifetime monitoring once he's in Florida. I don't know what Florida law is, but the way the statute reads here in Michigan and the way the law is today, I think the court has to order lifetime monitoring, and certainly if Mr. Jarman leaves and goes elsewhere in another state, he can certainly take the actions to petition the court at that point. But that's all I have, Judge.
Thank you, Mr. Gurmurthy. Mr. Jarman, you don't have to say anything today, but you're allowed to. Is there any statement you want to make or no?
I do want to say that I'm sorry. I'm I have made many mistakes over the course of my life. I've been in front of the courts countless times. I can't remember how many times I've been in front of courts, but this one's really woken me up and shown me that I do need to change my life. It's been a real eye-opener.
All right, thank you, Mr. Chairman. Ms. Goodrich, any recommendations from the people?
Oh, yes, Your Honor, thank you. The defendant is 35 years old with no prior felonies. He has 3 prior misdemeanors. He's unemployed with high school diploma. He did make some admissions to the police about engaging in sexual acts with a relative who was under 13 at the time. The plea agreement was that any incarceration would not exceed 96 months. The recommendation for incarceration is 8 years, which is consistent with the plea agreement. I would ask the court to follow the PSI recommendations as well as order lifetime electronic monitoring. Thank you.
Thank you. Mr. Jarman, if you please stand for the court sentence. Mr. Jarman, you're in front of the court now for sentencing on 3 criminal sexual offenses against a child. And today, you tell me, gee,
Defense confirms no scoring challenges. The prosecutor outlines Mr. German's age, the difficult nature of the case, victim under 13, his mental processing impairments and remorse, the plea offer history, and the family support. Discussion of an 8-year cap, prison programming, and the need for lifetime electronic monitoring once released.
I've been in front of courts a lot, but never really understood, the changes I have to make. Well, it's a real shame to this victim that you didn't understand those things, because now she's got a lot that she's got to carry. And, you're here today, I'm sure the normal thing is you're focused on kind of what's ahead for you on your path, and there's some hard things there, but you've earned those hard things. You put hard things in this child's path that she didn't deserve or earn. So that's something you got to live with. There is a sentence agreement for 96-month sentence or cap, and that is within the advisory guidelines in all 3 files. And it sounds like it was reached with careful consultation between the prosecutor's office and 2 different counties and the victim and her family. So for that reason, I'm going to go ahead and follow the recommendations of the Department of Corrections and the plea agreement. And in all 3 counts, order concurrent sentences and commit you to the Michigan Department of Corrections for not less than 96 months, nor more than 15 years. So that's 8 years to 15 years. You get credit for 272 days previously served. There's a crime victims assessment of $130, state cost of $204, and also on the due to the second degree CSC with a person under 13 and you being over 17, I am going to order as part of the judgment of sentence the statutorily required sentence that upon any parole from prison that you are subject to lifetime electronic monitoring. Mr. Jarman, that's the sentence of the court. I think it's proportionate. It's within the guidelines and consistent with the plea agreement. If you wish to appeal, you'd have to file an application to the Court of Appeals. If you wanted a lawyer, you'd have to make that request within 6 months. And if you did so, I would appoint a lawyer for you for the appeal. And you hand you a piece of paper about that appeal. Ask you to initial 1 copy. That's just so we have a record we gave it to you. The other piece of paper is for you to fill out if you do want to take an appeal and get a lawyer. Do you understand that? Any questions for me, Mr. Chairman? Good luck to you.
For the record, Judge.
Mr. German, offered the chance, delivers a brief apology and reflection on his mistakes. The prosecutor reads the PSI recommendations, 96 months, concurrent, with credit for 272 days, fines, and monitoring. The judge explains why he'll follow the plea agreement, imposes an 8 to 15-year term, orders lifetime electronic monitoring upon parole, credits, costs, and details appeal rights.
It's file 24-6853FH. Council, want to state your appearances, please?
Melissa Goodrich, Wayne County Prosecutor.
Luke Kuski on behalf of Mr. Rieger, Your Honor.
We're here for sentencing on a charge of operating while intoxicated, third offense, a 5-year statutory maximum. Guidelines were initially scored at 0 to 9 months. Have you had a chance to review the pre-sentence report and recommendations with your client?
Your Honor, I've had a chance to review the report recommendations. We didn't have any objection to the report recommendations and no scoring challenges at this time, Your Honor.
You, Ms. Goodrich, any additions, corrections, or scoring challenges from the people?
No, Your Honor.
And I would note, I also did have an opportunity to review, I didn't count them, but there were probably in excess of a dozen letters of support, predominantly from the AA community, as well as documentation of AA attendance on behalf of Mr. Rieger. Thank you for forwarding that, Mr. Kuski.
Thank you, Your Honor.
And anything you want to say on behalf of your client?
There is, Your Honor, and just briefly, Mr. Rieger finds himself in a sad situation here, being he's operating on intoxicated third offense. He was a successfully completed sobriety court just a few years ago, relapsed in this case, and here we are. What he's done since this case and since he's been pending the pendency of this, I guess, sentencing in this case, is he's started a Al-Anon meeting here in Sheboygan. He's brought that back. The community did not have one, and the AA community saw a need for it. Mr. Wyndham stood up and started a meeting, and he's passed it on to a friend of his, and they've been co-chairing that meeting, but he's been the one that started it and got it going. He attends AA very regularly, almost religiously, Your Honor. He's been very dedicated to sobriety. He understands this relapse and the situation he finds himself in is very unfortunate. He's got all the nice letters that Your Honor's had a chance to review. He's had this overlay on since this offense occurred, and this offense occurred back over a year, April of the year. So he's not had any issues on his bond for well over a year. He started new meetings here for the Al-Anon community. He's been attending AA religiously. He's been still counseling. He's got great employment. He's got his business all tied up and wrapped up so that it can be taken care of while he's incarcerated. All those reasons, Your Honor, I think set Wyndham apart from your normal drunk driving third offender that you see in front of the court. I'm not sure I've had a client that has amassed the AA attendance, the letters, and the credentials that Mr. Rieger has. And albeit he's still on that path for sobriety, and he's still moving forward in that direction and moving forward in the right direction, Your Honor. So I'd ask the court, the recommendation and the agreement was not to exceed the midpoint of the guideline range. The guidelines are 0 to 9. The recommendation here is just the 30 days. I'd ask the court to adopt that recommendation, just setting Mr. Rieger to the statutory minimum 30 days. So he can get back out and continue to provide a service to this community that is desperately needed with the AA community, the Al-Anon, and all that good stuff that he's doing, Your Honor. I'd ask the court not to overlook that because this is his third offense. Thank you.
Thank you, Mr. Kuski. Mr. Rieger, it's not required that you would say anything today. You don't have to, and if you don't, I don't hold that against you. You're also allowed to say anything you wish. Is there any statement you want to make, sir?
No, Luke said it pretty well. I'll just leave it at that. Thank you.
Okay, very good. Ms. Goodrich, any recommendations from the people?
Yes, Your Honor, thank you. The defendant is 60 years old with no prior felonies, 4 prior misdemeanors. He's self-employed with a high school diploma and 3 years of college. We're here because on April 10th of 2024, the defendant was viewed crossing the center line, having difficulty navigating curves. He did admit to consuming at least 4 beers. His blood test came back a .214, more than double the legal limit.
New case introduced. File 24 to 6,853 FH. OWI third offense. 5-year max. 0 to 9-month guidelines. Defense and prosecution confirm review of the report and no scoring disputes. Defense highlights Mr. Rieger's relapse in April 2024, his pivotal realization of alcoholism, and his extraordinary AA attendance and letters of support.
The PSI recommendation is for 30 days. When looking at Mr. Rieger's history in 2007, He had an impaired in Sheboygan and received fines and costs. In 2008, he had an OWI with 2 years probation. In 2013, he had an OWI third that was reduced to a reckless and 10 days jail. In 2020, he had an OWI third reduced to an OWI second with 1 year in jail and 2 years probation. Now we're here on this new conduct from 2024. For the first time, he is a convicted felon, but I do believe that the jail time should be more than 30 days. I would recommend 3 months jail, which still would be consistent with our plea agreement for mid-guideline range. Thank you.
Okay, I'm going to assume that the year imposed in the district court matter would have been suspended when you were in recovery court. You didn't actually do a year in jail on that, right? Okay.
Sobriety court.
All right, Mr. Rieger, if you'd stand for the court sentence, please. All right, well, Mr. Rieger, you're 60, you don't have any prior felonies, but you know, the prosecutor outlined your history with drinking and driving, and it's a very troubling history. We've got great letters from the AA community about your commitment to sobriety, and that's fantastic. And it sounds like you were involved with them beforehand, and they talk about your slip or your relapse and then coming back, and that's, you know, that's fine. And I'm glad you're back involved in that. That's going to be a necessary part of your success, continuing on with that fellowship. But it's important to recognize that, you know, you are not standing in front of a judge today because you had a slip, because you had a relapse on alcohol. It's because you drove while drunk. There's no addiction that makes you drive. But for some reason, you repeatedly make decisions to drive after you've been drinking. You don't strike me as somebody that wants to do harm to other people, but you could wreck somebody's life or take somebody's life every time you do this. And what's really troubling to me is, you know, the officers on the scene, when they pull you over and, you know, clearly you're not driving right, and they asked you about how much alcohol you drank, and you said, within my boundaries. I mean, somebody that's got 3 prior convictions and 4 prior arrests for drunk driving and has been through a sobriety court, to be twice the legal limit and telling an officer when he's driving that you're within your boundaries shows to me not just a relapse, but a profound misunderstanding of the nature of your disease at that time. I hope you're in a better place now, but it's tough to figure out, you know, what to do. The guidelines at 0 to 9, you know, would call for an intermediate sanction, which would mean we shouldn't give any jail unless there's reasonable grounds to do so. Here, there's a mandatory minimum 30 days, so we at least have to do that. But, you know, these guidelines don't adequately take into account, they do take into account prior history. What they don't take into account is that you keep doing the same thing. And that places people at serious risk of harm. Prior probation has not been working well. You had a treatment court, and that has not been enough to keep the community safe from Wyndham Rieger driving drunk.
Is it too late for me to say something? Or can I say
Go
something?
ahead, say something.
I said that I was an alcoholic in the past, but I didn't truly believe it until April 10th of last year, when I finally said, I am an alcoholic. And it finally clicked, you know, that.
Defense emphasizes that Mr. Rieger founded a new AA meeting locally, maintains employment readiness, and is on bond without incident. They ask for the statutory minimum of 30 days. Defendant declines to add to the record. The prosecutor recites Mr. Rieger's for prior OWI-related matters, his .21 4BAC, and recommends 3 months jail consistent with the plea.
That's true. I hope that's true.
That's all I want to say.
Oh. Well, and that's consistent with, you know, what I'm saying is that up until last April, you didn't really have an understanding of what was going on. So it's tough to know, you know, really what to do with you because, you know, we've tried a lot of different things. Presuming that you didn't do much jail in recovery court, you know, it looks like the most you've done before is around a month. You have sentence agreement for a midpoint cap. This is a true fourth conviction. There was another one that where you were arrested for an OWI third, pled to reckless. I don't really know a lot of the details about that. But that's a troubling driving history. So taking all those things into account, I'm going to place you on probation as recommended for 18 months, subject to the terms and conditions listed on the pre-sentence report on pages 2 and 3. They include, I want to highlight some things, obtaining a substance abuse assessment following the recommendations, a curfew, 60 days of community service, employment, court costs of $350, crime victims assessment of $130, fine of $500, $225 OUIL reimbursement, DNA testing with a $60 fee, $68 in state cost, and a monthly supervision fee. And in terms of a jail sentence, I'm going to follow the prosecutor's recommendation for 3 months in the Sheboygan County Jail with credit for 2 days previously served. I'll indicate on the judgment that I have no objection to your participating in any jail programming, including CBT or trustee status, if the jail determines you're eligible for that. That doesn't mean you get to demand those things of the jail. Sometimes when I say that, they go back to the jail and say, how come I'm not a trustee? That's just me saying, I don't veto those things. It's up to the jail administrator what programs they want you in. But if they approve you for any of those, I'm going to have pre-approved on my end.
You got it.
And that can shorten your sentence.
Does that include the work release, Your Honor?
I would not allow work release. No,
You're not allowing work release during those 3 months?
I'm not.
Okay, well, I'm done working for the rest of my life.
Well, then you're done working for the rest of your life. I don't care.
Okay.
I'm not letting you out of the jail. You're serving that time, and you're lucky it's only 3 months. And you're not done working for the rest of your life. You can get out and get a job. In fact, I promise you, you're not done working for the rest of your life, because a condition of your probation is that you work 30 hours a week minimum. If you don't, you'll come back and do some more jail.
I guess what I meant was.
Mr. Rieger, you should consider seriously stopping talking right now. I've announced my sentence. I believe it's proportionate. It's within the guidelines. It's consistent with the plea agreement. You're eligible for early discharge from probation. If you successfully complete the terms, I'm going to hand you a piece of paper about that. If you want to appeal, you can do so. If you want a lawyer, you got to ask me within 6 months. We're going to hand you a piece of paper explaining that and ask you to initial one copy for me. The other one's for you to fill out if you wish to take an appeal. Within 24 hours of your release, you must have contact with your supervising agent. And I hope, and you should hope, that you don't come in front of me in violation of probation.
Thank you, Your Honor.
Judge's sentencing lecture stresses the danger of repeated drunk driving, the insufficiency of past interventions, and the risk to public safety. Imposes 30 days in jail, no work release. 18 months probation with substance abuse assessment, community service, curfew, fines, fees, and supervision conditions. Reviews appeal rights and probation discharge options. Then closes the hearing.